take roll and move on.
Judiciary Committee will come to order.
Okay, we've got, do we have,
Mr. Co-Chairs, you have a quorum.
okay, we've got 26 bills. We're not going to, if we've heard the bill before, we're not going to have a hearing on it. We'll just, the bill will be called, the patron will be given a minute or two, and then we'll take action. If, and a lot of these bills have to do with bills we've heard in the recent past, maybe not this session, but we've got 26 bills. I'd love for this to be our last meeting. I think that we've got one more bill that's coming from another committee, so there probably will be at least one more meeting, albeit brief. So if we don't get through this, there will be another chance. But the bills that have to go to finance have to go today. And a number of these bills have to go to finance. Do you want to do a sign-up sheet or just go by?
We already, we have a sign-up list under the request to present you.
Okay. Mr. Wyatt, your first, Delegate Wyatt's first. Wyatt, you're first. Ms. Delegate Wyatt.
Good morning, Mr. Chairman and Senators. I'll be very brief. House Bill 123 before you.
Okay, House Bill 123, this is not a bill that we've seen before.
Amends the Code of Virginia to increase from a Class 1 misdemeanor to a Class 6 felony if an individual would destroy, injure, remove, tamper any firefighter equipment, vehicle, or law enforcement vehicle or equipment. I can explain why my premise to support our first responders in my district that took an oath to protect and serve the citizens of the Commonwealth. We need to stand beside them, and hopefully by increasing a little tougher offense, it will deter anyone that damages any law enforcement vehicles. And I think there are one or two individuals represent the law enforcement community and the fire and EMS that would like to speak on this bill as well.
Okay, very briefly, you understand, Mr. Senator Morsi.
Good morning, Delegate.
And I could have, excuse me, Mr. Chairman, I could have gone into much more detail, but I know you said be brief, so I want to respect your time.
Good morning, Delegate.
Good morning.
We already have a code section that would make damage to personal property above a certain amount of felony. Why are we making, increasing this from a misdemeanor to a Class 6 felony when there already is legislation that would cover that?
Mr. Chairman, I would answer the Senator to lead as a deterrent. Many of you all are very accomplished attorneys. I am not. I just interact with a lot of the volunteers and the fire and EMS and law enforcement folks in my district. And the premise of this bill is strictly to increase awareness, and we have seen that increase over the last few years. Law enforcement individuals take their vehicles home. There are tires slashed. There's glass broken. It would, my thought process and the folks that I interacted with in my district that serve in that capacity as law enforcement and fire and EMS, I feel that it will lead to a deterrent if you raise the offense.
All right, thank you, Mr. Chair.
Okay, you've got a couple of witnesses, and I'd ask you, please be brief. A couple of minutes per side.
Mr. Chairman, Wayne Huggins, representing the State Police Association. For the reasons that Delegate Wyatt has cited, and I can personally attribute that those things have happened to me when I was a uniformed trooper, we support this bill. Thank you.
Thank you very much. Yes, sir.
Mr. Chairman, Ed Rhodes, representing the Virginia Association of Rescue Squads and the others in the EMS community. We support this bill. Ambulances these days cost up to $500,000 or more, and to replace one or even pieces and parts of it takes a while. So, like I said, we support this bill.
And you understand if somebody does more than $1,000 worth of damage, now it's felony.
I think.
Okay, are there people in the Zoom world that will need to speak to this bill?
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised at this time.
Okay, the bill's before you. What it does is it raises from a Class 1 misdemeanor to a Class 2 felony. destruction of personal property belonging to a fire rescue squad or emergency vehicle.
It's got 6 felony.
Class 6 felony, I apologize.
All right.
Got a motion to report of here.
Mr. Chairman, this bill would need to go to finance.
It needs to go to finance, so motion to report and re-refer to finance.
I'll second.
Are there additional motions? Are there, open the roll, vote yes is to report and re-refer to finance.
Ayes 5, noes 6.
Okay, the bill is not reported.
Thank you, sir.
Thank you, sir. Excuse me? It would change the outcome. It would. That's right. It still wouldn't report. Delegate Bell is next, and you have several bills. Delegate,
I do. If you're trying to do the cognates, I only have one. I'm happy to, I'm not in any hurry today. If there's other.
if you have a cognate, that would be best to go
Yes, sir.
first.
Mr. Chairman, members of the committee, I have House Bill 1198. I understand that what bill is as amended is identical to as amended Senate Bill 563 by Senator McDougal. Because he's not here, I can say that obviously you would like me more than him, and will therefore surely treat the bill differently.
1198, you will recall, was a bill that
I just have to present
was
it.
passed by indefinitely in this committee, or 563 at that point. It was passed by indefinitely on a 7-to-8 vote. So what this bill does is allows the Attorney General to organize or to prosecute sex crimes when they're committed against children.
Yes, sir.
It's identical to Senator McDougal's bill.
Yes, sir. As amended and as his was amended,
Okay,
that's
are
correct.
there motions on the bill? What's the substitute motion? Okay, is there a second on that?
Second.
Substitute motion takes precedence. Please open the roll.
Ayes 8, noes 5.
Okay.
I'll go back.
What's your next bill, Delegate Bell?
I have a bunch. If I'm happy to do them if you're ready.
Keep going.
Okay, yes, sir. Mr. Chairman, we have two measures where I anticipate amendments. Having spoken to members of the committee, that would be House Bill 736, involves the timing for search warrants.
And the internal discussion we had about this was perhaps to keep the search warrants during the daylight, not federal in compliance, but to go like 7 to 6. The internal discussions on this side, Senator. Does that make
None
sense?
that you're invited to, I think.
7 a.m. to 6 p.m.?
Mr. Chairman, I'd move that amendment. I'd also move a reenactment clause.
Okay.
I second that motion.
7 a.m. to 6 p.m. and reenactment calls. Is there further discussion on that motion? Say, all in favor of the amendment, say aye.
Aye.
Opposed, no. Okay, is there a motion on the bill? Okay, is there a second on that? Are there people that need to speak on this bill?
Given what you're doing, I don't know, but I'm happy. Yes, there are people ready to testify if the committee was planning to sort of take it up substantively and operate, but
Well, we've got a motion to report as amended, and it doesn't have to go to finance, so all in favor say, vote, open the roll.
not anymore.
Okay,
Ayes 11, noes 2.
and your next bill, Delegate Bell.
In the same posture, a bill that I understand will be amended and then sent off to conference, is House Bill 735, Mr. Chairman.
Okay, 735 is the bill that has to do with the earned sentence credits. Another bill that we spent a long time on a couple of years ago.
So Delegate Bell doesn't just repeal what we did last year.
The original version would, yes, sir.
Is there,
My understanding is there's amendments coming, and then we'll have a discussion about whether the
Okay, you have the
consensus can be
substitute before
reached.
you. Do we want an explanation of the substitute before we vote on it? Is this, Senator Serval, is this your substitute? Yeah, I would like it. Okay, it's Delegate Bell's substitute.
Oh, that's a different, okay, that's not what I thought was going to happen. I'm happy to talk about the sub, but my expectation was that you all were not interested in my sub at this point. I thought so, to put it in conference. All right, Mr. Chairman, members of the committee, this substitute would directly address the issue of the original charge being on the excluded list and a secondary charge not being on the excluded list. I would say if you want to work from this, that's fine, but I'm not, I would, again, we're,
Excuse me? You want to adopt the substitute and then put a reenactment? Okay.
Mr. Chair,
Senator Peterson.
can someone just, in plain language, tell me what the substitute
I will.
does? It seems to speak to concurrent versus consecutive sentences. Thank you,
yes, sir. Okay, so,
Before he does that, Mr. Chair,
and I'm not,
am I looking at the final iteration?
You're looking at the substitute that came from Delegate Bell, but not with Senator Serval's amendment.
yeah, this doesn't really, I'm happy to have you have it. This was kind of a discussion piece. I wasn't aware that we were going to bring it up. I'm happy to tell you what's in it.
Senator Peterson
Okay,
wants
so
to know the
If
difference.
Delegate
between
Bell
that.
could explain.
Yes, sir. Well, I mean.
1:53
Yes,
PM.
sir. No, right, that's fine. I just, members of the committee, the issue was that when the original bill was going through, DOC at the time had difficulty identifying who would be the beneficiaries of the increased earned income credits. What they discovered when they finally had them down to the individual number is that a large number of people that are on the excluded list, and so 43 people who committed capital murder, 1,275 who committed homicide, were getting a reduced sentence, not for that offense, which is excluded,
Right.
but secondary offenses which they committed at the time. That's what this bill as amended, the substitute would try to get at, which would be everything is put back in, it doesn't repeal, but it does add an additional language in section F that reinstitutes the 85% cap if the person is serving, meaning at the time is serving or has been sentenced to serve a concurrent or consecutive sentence on an offense enumerated in subsection A. Now, it is not trying to get at people who 20 years ago had an excluded offense. It's trying to get at ones who at the time they get the excluded offense also have, at the same time, some of these ancillary offenses. This was, when I did it, more just a start point or a discussion as an idea of how to get at it. I'm happy to have a whole discussion
Okay.
today, but my expectation was we're not going forward today with this, but simply to put it in conference.
Right.
If you wish, you can go back to the original. Since you're putting it all in conference, I think this is closer to where we're trying to, it's a closer tie to the actual problem, but for all that, Mr. Chairman, I'm happy to handle this
Mr.
every wish.
Chair.
Senator Peterson.
Let me just ask a follow-up, because here's the trick. First of all, if it's a concurrent sentence, you'd get no relief now, correct?
Well, it's based on the duration. So let's say you have a 10 years for murder and 12 years for a larceny. It'd be an unusual circumstance.
But
if
my
that happened.
question is yes or no. If it's a concurrent sentence, you get no relief.
That's not
under the
accurate,
current.
Mr. Senator. I'm trying to explain.
I'm sorry, okay.
If you don't get none for the 10 upon which it is concurrent, but the remaining 2 years that are in the non-excluded crime, which is not simultaneously covered by an excluded crime, you could get some credit for that.
I think the answer to my question was yes. If it's concurrent, you don't get relief. Mostly yes.
For the concurrent.
Mostly
For the
dead, yes,
concurrent,
sir.
exactly, for the concurrent. So my question is, what you're really talking is about a consecutive sentence, where if someone, let's say they had 40 years for first-degree murder and then 5 years for stealing a vehicle, that they don't get any relief on the 40, but they do get relief on the 5.
Mr. Chair, I think it's certainly the more common circumstance. I do think occasionally, per DOC, there will be cases where the excluded offense, let's make it a robbery and a larceny, probably is a better fact pattern.
Okay.
You have 5 years for robbery, 10 years for larceny. The original 5 years, which is concurrent, overlaying
Right.
each other, you do not even now get any good time for it. There's no, because that 5 is the same 5 for which you're not getting the good time credit.
I got you.
The remaining 5 on the larceny, if you finish the robbery, you're now just in a larceny, they're giving the expanded credit for.
Okay, I
So
appreciate
there's
that.
surely a rare circumstance.
And I
but
agree, it's a little bit more nuanced than I tried to ask in my
Morrison.
cross. Thank you.
Delegate Bell, I'm going to
Yes, sir.
try to be very concise, and I hope your answers can be equally concise,
I'll
maybe
try.
one word. Right now, on a major crime like the rape, robbery, murder, which we can call predicate crime or whatever, That person, right now, and in your legislation, will serve 85% of their time, correct?
For that charge, yes, sir.
For that charge. Now, any other charge, called an ancillary charge, the judge could either give a concurrent sentence, imposition of sentence suspended, or consecutive, correct?
Yes, he could certainly organize the charge in the sentencing document how he chose.
And Judge Peterson, Senator Peterson asked him,
I could.
Senator Peterson said that it's only when you have a consecutive sentence are we giving a reduced sentence, but only for that ancillary charge, correct?
That's what he said, yes, sir.
All right, final question.
Senator Morrissey.
So if an individual gets a 40-year sentence, you mentioned a moment ago for murder, a 40-year sentence, and then gets 5 years for larceny, 5 years for drugs, on down the line, the person does 85% of that 40-year sentence and then just gets good time for the remaining offenses, correct?
If it was all consecutive and he had an included and excluded offense, he would get 85% for the excluded offenses, which are, it's a different list than the most serious crime, but let's call them the most serious crime, and then would get the reduced rate if he qualified, and he has to qualify, but would get the reduced rate for the ancillary offenses. Yes, sir.
Thank you,
Senator
Delegate Bell.
Boysko.
Thank you, Delegate Bell. I see in here there is one other change that is proposed on line 58,
Yes, ma'am.
where you're giving them the ability to change their minds whether or not they want to even give anybody the credits.
That is not my change. That's a change DLS made as technical. I have no, I'm not attached to that. That's not what this is about. If in any way makes the Senate more comfortable, put it back. And Mr. Quagliata wants to explain why they would, DLS prefer to have it that way, but it's not something, that has nothing to do with my bill.
Mr. Chair, I move that we take the may out and put the shall back on.
Well, we need
line
to adopt the
58.
substitute, and then we can amend it.
Okay.
Okay? Okay, been a motion to adopt the substitute's been seconded. All in favor, say aye. Aye. Okay, and anybody opposed? Senator Boysko's got an amendment to the substitute, and that is to replace the word may on line 58, unstrike the word shall.
Mr. Chairman,
Is there a second on that motion?
I think so, Mr. Chairman.
Second, okay. Senator Servell.
Mr. Quagliata looked like he was about to explain the may shall, because I guess he suggested it. I was curious what the rationale was.
Yes, Mr. Chair. So the rationale of changing the shall to the may is simply in the other sections in the chapter that deal with earned sentence credits. The chapter mentions that earned sentence credits are basically adhered through rules prescribed by DOC, which reflects some sort of discretion upon DOC in awarding these earned sentence credits. So it was just a clarification saying, in context of all the other sections in this chapter, that the earned sentence credits may be awarded and calculated using the 4-level classification system.
Senator Servell, Senator Boysko, do you have any?
I still think we should restore it to what it was.
Okay. All in favor of Senator Boysko's amendment, say aye. Aye. Any opposed? Okay, one no.
I have another question.
Senator Edwards, Chairman Edwards.
On line 93, notwithstanding any other provision of this section, a maximum of 4.5 sentence credits may be earned. Shouldn't that also be shall?
Yeah.
Line
So-
93.
All right,
yeah.
so Mr.
Charles-
Chair, I would just say on that line picks up the existing language in subsection A saying a maximum of 4.5 sentence credits may be earned for 30 days.
And here's the problem, you still have to earn the earned
what's saying,
credit
sir.
has to be earned, and so it's may is appropriate there. I would,
Yeah.
Senator
Mr.
Boysko.
Chair, I just want to clarify. So all of this is based on the operating procedures in DOC. They have the standards and the guidelines on what offenses would be considered violations. There's a pretty comprehensive set, and giving them that ability to make those decisions, since they are day in and day out, I think makes more sense.
Mr. Chairman,
Senator Servell.
thank you. I would also move a reenactment clause.
Senator, second, a motion and a second, put a reenactment clause on the substitute. Is all in favor of that amendment, say aye. Aye. Okay, 2 noes. Got a few more no's. I got it. Okay, we've got a reenactment clause on there, and we've got the bill amended. 9-6. 9-6. I can count. I can count.
Give or take.
Okay, you've got a reenactment clause. You've got the bill amended. The bill's before the committee.
This one needs to go to.
It has to go to finance. Refer to finance. Is there a second on that motion? Okay, are there other motions?
Yeah, motion to pass the bill by indefinitely, Senator Boysko, and I
Okay.
second the motion.
Okay. Senator Morrissey.
Thank you. We're moving quickly, but I think we owe I want to give the patron, a few sentences as to why I'm going to take the step that I'm about to do. Senator Bill, we appear to be on a track, Delegate Bell, we appear to be on a track to pass by your bill indefinitely. But I want you to know how I feel, and I think some other folks have the same sentiment. And that is this. The whole reason that we adopted the earned sentence credits was to incentivize prisoners to, whilst they're in prison, to do well, take advantage of every program, every educational program, every activity or job training program that they have in the prison to better prepare themselves if they were to ever get out. If we were to pass this bill, it would remove that incentive, and I think that's a bad thing. The last thing that I'll say is, well, that's it. Thank you, Mr. Chair, for your time.
Senator Morrissey. Okay, the motion is the PBI. All in favor? Excuse me, and it's been seconded, yes. So
Speaker.
open the roll, all green votes, the vote's PBI.
Ayes 6, no 8.
Okay, we'll go back to the main motion, which is to report and refer to finance. Okay, all in favor of reporting and referring to finance, vote yay.
Ayes 9, noes 5.
You've got another bill, Senator Delegate Bell.
Yeah, I do. This is one where, this is 1352. It involves mandated reporters and protections against job impacts. Senator Surville pointed us to another code section, which would be an entirely different approach, probably ultimately better. We're not ready to get this done this year. I'll bring it back. I would ask you to table the bill, bring it back next year. Hope someone on this committee will bring a Senate version and we can proceed
Well,
from there.
we don't table the bills over here, but what
PBI.
we can do is just, Delegate Bell.
Pass by is fine. Pass by, whatever's there.
Pass by for a year.
Mr. Chair,
I want to start fresh, so
Okay.
I would just assume.
Mr. Chair,
Senator Peterson.
I actually liked this concept. Would this not be covered under the current whistleblower statute?
We don't think so, but again, this is a busy time, and I think we can get at this, and I'm going to bring it back next year, and if you want to be the Senate
Sure.
advocate,
All right, well,
yeah.
all right. Yep.
Okay, substitute motion to pass by indefinitely, pass by indefinitely gently, is that seconded? Okay, all in favor, say yay.
Thank you.
Thank you.
Thank you, Mr.
Is
Chairman.
that it?
Yes, sir, thank you.
Okay, next is Delegate Anderson.
Good morning, Senators. House Bill 25 is somewhat to what was happening with Delegate Bell's sentencing credit bill. Simply what this does is it removes first offense child pornography possessors from receiving earned sentencing credits. That's all it does. It was intentionally put into the bill, and I'm seeking to pull that sole charge out of individuals who could receive.
Does everybody
sentencing
understand the
credits.
bill? We haven't heard this before. Are there people that need to speak to this bill?
I don't think so.
Are there motions? we've got a move to report and a second and substitute motion. What's your substitute? Okay, motion to PBI. Is that seconded? Second. Okay. Substitute motion takes precedence. Please open the roll. Green votes, the vote's PBI.
Ayes 9, noes 5.
Okay, Delegate Anderson, you have another bill.
I do. It is 1356. It does two things. One, it adds fentanyl to our existing distribution charge, 100 milligrams of fentanyl, as a transportation and importation offense. It simply adds 100 milligrams to 18.2248.01. And secondly, it allows individuals who are selling counterfeit pills that are actually fentanyl to be charged with murder or attempted murder if those pills have more than 2 milligrams, which is a lethal dose. 14 million fake pills are sold every year, mostly on the internet, to Americans who think they're buying Valiums and Percocet and other drugs, and they're actually fentanyl produced by drug cartels in Mexico from Chinese products. So it creates a ability to charge those distributors with murder or attempted murder, depending upon if the person dies.
Mr. Chairman, I have a question for council.
Senator Servo.
Can council confirm that if we pass this, it'll create a new mandatory minimum?
Mr. Chair, it would create a new mandatory minimum in the transportation involving controlled substance in the Commonwealth. It does have a 3-year mandatory minimum for the first sentence, and a second or subsequent conviction is a mandatory minimum term of 10 years. So adding this would create 2 new mandatory minimums.
And if I can counsel, isn't it true that first offense drug distribution is punishable by 40 years now? And that second subsequent offense is punishable by life?
That is correct, Mr. Chair.
Senator Morrissey.
Delegate, we have passed a law before you got here that allowed for the following situation. If an individual distributed fentanyl with another individual, that person overdosed, either person overdosed, and a call was made to secure aid from 911, that person could not be prosecuted. Can you explain to me how your bill would affect that situation if the person was aware that it contained 2 milligrams or more of that detectable substance? Would that person still be able to avail himself of what we sometimes refer to as the Good Samaritan law?
Sure. Senator Morrissey, thank you for the question. We're thinking about drug dealers as street dealers. This is attacking the people that are selling things over the internet as counterfeit prescription pills. So that person would unlikely be in the proximity of the person overdosing. What's happening is Americans are going online and they're buying things from pharmacies that they think are pharmacies, and they're buying Valium and whatever other drugs they're buying, and they're just fentanyl. And they're being imported into Virginia, and they take them and they die because 2 milligrams is enough to kill you. As far as the mandatory minimum question, if I could just say one thing to that, it doesn't technically add a new mandatory minimum. It adds fentanyl to our current law, which does have mandatory minimums. That's what it does. So I wanted to clarify that.
Follow-up question, Mr. Chair.
Senator Morrissey.
I'm looking at the language in lines 102 at SEC, as well as the language in 110 through 129. It appears that it is not limiting a person from distributing the substance just on the internet, but it covers, it's very broad, and it covers a situation where somebody distributes the drugs to another individual.
Senator Morrissey, I want to make sure I've got the right bill. My bill only has 50 lines.
Mr. Chair, I believe Senator Morris is looking at the introduced version and not the substitute that the House adopted.
Yeah, there's only 50 lines, Senator Morrissey.
Okay. The House has a substitute bill. It
I'm sorry,
might have the same language.
My apology.
I don't know if it has the same language or not.
I'm sure somebody else might have a question. Give me another moment.
Okay.
Mr. Chairman, the senator is correct. This is not limited to internet sales. So somebody distributing one of these, say a counterfeit Percocet pill on the street, would also fall under this.
I'd ask counsel, does this statute require that the Commonwealth prove that the perpetrator knew there were 2 milligrams of fentanyl?
Mr. Chairman, it does not, because it's also satisfied if you should know that it contains fentanyl. And Anybody engaged in this business these days knows that fentanyl has invaded all illicit street drugs. If you're selling a Percocet, if you're selling oxycodone, you know it's probably fentanyl. If you're selling heroin, you know it's probably fentanyl.
Mr. Chairman.
Chair.
Senator Stanley.
Yeah, being a criminal defense attorney, I don't think that it's that easy just to say, well, if you're selling Percocets to your friend, you should know that it could be fentanyl. I think there's a little bit more of a scienter requirement than that. But we're talking about something right now that is, you know, I didn't think it could get any worse than Southside, Southwest Virginia rural areas when it came to meth. Well, we found something to top meth. And unless we take this very seriously, then it's just going to spread like an ink stain until obviously everyone will be affected by this one way or the other. So I think knows or should have known, should know is still, as a defense lawyer, if I have a guy who thinks he's giving 2 Percocets to his friends, turns out it's fentanyl, he got it from somebody else. How do you know he should know? Just because what if he doesn't read the newspaper? What if he doesn't watch TV? I mean, so what, I really take issue and respectfully disagree with my friend, Mr. Benjamin. Thank you.
Mr. Chair.
Senator Morrissey.
Delegate Anderson, I am not as hung up on the words should or should have known, although I agree with much of what Senator Stanley just said. But what is clear is that this bill captures a situation and would require a sentence, including a mandatory minimum, for somebody who distributes fentanyl to another individual and then calls it in and says the person is ODing, okay? We have made a policy decision in the General Assembly that it is more important to save lives than to secure a conviction. And the problem that I have with the bill, and I respect your intention, what you're trying to accomplish, would undermine what we have already accomplished by saving lives and encouraging people to call in when there is an abuse.
Mr. Chair, if I may just respond briefly. Senator Morrissey, I think you're conflating the words distribution with importation. So what happens is 18.2-248.01 is the importation statute, not the distribution statute. So somebody who orders 100 milligrams of fentanyl from China, Mexico, whatever, it's coming into the Commonwealth, that transporter would receive that mandatory minimum. They're not the distributor, they're the importer. The distributor would then be charged with murder or attempted murder if they're distributing more than 2 milligrams of fentanyl at the time of the sale, knowing that that's what they were doing.
Senator Morrissey.
So the 2 individuals that get together and are using drugs together, happens all the time in the same locale that Senator Stanley just spoke about. That person sells, distributes that fentanyl to another individual in their home. And he ODs, I believe, and I'll ask staff, doesn't this legislation cover that incidence of distribution?
Mr. Chair, if I am to understand Senator Morris's question, yes, the providing or the selling of a small tablet that does contain 2 milligrams of fentanyl, that would be a distribution. So to the extent that Senator Morris is saying, 2 friends hanging out and one sells them a pill, that would be covered under this bill.
Thank you.
And Senator Morrissey, that would be the kid giving the other kid fentanyl without the other person knowing they were getting fentanyl, and the person giving the fentanyl intentionally giving it to him without their knowledge. So it's a little bit more of a unique situation than 2 college kids hanging out. It's somebody who's basically selling Adderall, but it's fentanyl, knowing he's selling the Adderall, but it's fentanyl, and then the person takes the fentanyl, doesn't know it, and then dies. They're murderers, and they need to be treated as murderers.
Senator Boysko.
Mr. Chairman, thank you. So I understand your intent, but the way I'm reading this, it does not say that. This says, in the bill, sale, gift, or distribution. So I'm not reading that, and I don't interpret that as a dealer who is bringing something in from another country or wherever else. This, to me, says 2 friends are sitting on the couch together, and one gives the other person this pill. I just think if you want it to be about distribution specifically, then we should make it about distribution specifically, incoming, receiving, selling, however much. I think this is very, very broadly written. I appreciate the intent here, We all know that we have a problem here, but I feel that this is a little too broad.
Senator Boysko, if you look at line 30, it says, without such person's knowledge that the substance sold or given contains that mixture. So I think I respectfully disagree. I think it's very clear that this is a unique circumstance where somebody intentionally gives a pill to someone without their knowledge that it contains fentanyl, and that person takes it and dies.
Okay, bills before, are there people that need to speak on this bill?
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised. Or, Mr. Chairman, we do have one hand raised now.
Okay, would just very briefly tell us whether you're for or against, who you are, and whether you represent a group.
Justin Griffith, would you please unmute and begin your testimony? Justin Griffith, would you please unmute and begin your testimony?
Yes, good morning. My name's Justin Griffith. I'm a Democrat-elected Commonwealth Attorney of Pulaski County. We support this bill. We absolutely use the Good Samaritan reporting an overdose to not charge somebody. We certainly want to encourage people to do that. It's my understanding that that immunity only applies to possession, when people possess that. And it's my understanding this bill doesn't deal with possessing. This bill is trying to target those that sell, give, or distribute. So we just don't believe it would interfere with that, and we strongly support this bill. Thank you.
Thank you, Mr. Griffith. Okay, the bill's before the committee. If it's reported, it needs to go to finance.
Second.
Got a motion and a second to report and re-refer to finance. Are there other motions?
Substitute motion.
Senator Lucas.
Move the TBI.
Move the previous question.
Second. Moves the previous question.
Which is the first bill, first motion. First motion is the previous question.
That needs to go back to the original.
Yeah, the original motion. You gotta order the previous question, just vote on ordering the previous question. No, just order. Motion to order the previous question, or not.
So that's the question. Shall the previous question be called? So all in favor of that, vote green.
Ayes 5, noes 9.
Okay. So the substitute motion was to PBI. All in favor of that, vote green. Okay, thank you, Delegate Anderson.
Ayes 9, noes 5.
Delegate Freitas, you're next.
Thank you, Mr. Chairman. I have two bills before the committee. Would you like to start with HB 325?
Whatever your choice.
Okay, so HB 325, Mr. Chairman, all it does is it removes a provision that was put in the code 2 years ago, which essentially assessed a fine for someone for failing to report to local law enforcement, the Department of State Police, within 48 hours after such person discovers the loss or theft, or is informed by a person of knowledge of loss or theft of a firearm.
That
Again,
does a provision we put in 2020 that requires you to report a stolen firearm.
a lost or stolen firearm, and assesses a penalty for doing it, Mr. Chairman.
Does everybody understand that bill? Are there people that need to be heard on that bill? Substitute motion.
Second.
Okay, substitute motions before you. Oh, please open the roll. Vote green is vote to PBI. Okay, Delegate Freitas, your next bill is 350.
Yes, 350, essentially what happened
8 to 7.
2 years ago, we put a provision in that said that if there was a threat against a member of the General Assembly, the governor, the judiciary, essentially, that could be, unlike anybody else that received threat or harassment, that could be prosecuted within the city of Richmond. I don't think we need a special jurisdiction for ourselves. We can essentially still file a claim if someone issues us a threat or a harassment. And typically what would happen is that the jurisdiction would either be the place for which the threat originated or the place for which the threat received Again, I don't think elected officials and other members need a special jurisdiction where the threats for us can be heard. And I'd be
Again,
happy to
this is
answer
something that changes, a change we made just 2 years ago. Is that correct?
questions. Correct, Mr. Chairman.
Okay. I think, does everybody understand it? Senator Morrissey?
I understand this, but can you tell us what the logic was 2 years ago to make a special bill?
Wasn't my bill, Senator Morrissey.
But you know everything.
I think part of the idea is you don't know where the complaint, where the trouble's coming from sometime. And so the idea was you had to have venues somewhere.
Mr. Chairman, so there's two jurisdictions, as I understand it was explained by counsel, that can prosecute this, either where it originated from or where it was received. So it's hard to imagine any sort of scenario where you would actually prosecute a harass or a threat if you didn't have a place where it was originated or a place where it received. This adds something completely different to where if it's us or the governor or the lieutenant governor, then the city of Richmond can handle it. And that's the part where I don't quite understand the logic associated with it.
Senator McClellan.
Thank you, Mr. Chair. I think part of the logic was for a lot of these officials, particularly the 3 statewide, they live here or are here a significant part of the time, and it's an or. So venue can be where it was received, where it was sent, or in the city of Richmond. But if the threat is by cell phone and someone drives out to Bristol to make a threat, but they live in, Charlottesville, that's the only connection to Bristol that there is. So it just gives you a third option that is convenient to where the victim of or the subject of the threat is a majority of the time.
Senator Morrissey.
I appreciate what my colleague, Senator McClellan, said, but one thing that we know with certitude is the person that received the threat, we know where they were located. And what this does, right now, a person makes a threat in Pulaski County to somebody in Patrick County. Those are the 2 venues, where it was made, where it was received. But what we did last year is we said, well, let's allow it to go venue to be held in Richmond. And I hope I didn't vote for that bill last year, but if I did, I made a mistake, and I'm going to correct it this time.
All right.
I don't think I made a mistake, Bill.
Okay, I think everybody understands the bill.
All right, I move to report the bill.
Are there other motions? Okay, motions to report.
Speaking to the motion.
Speaking, Senator McClellan.
I mean, if you look at the existing law, it says if venue cannot otherwise be determined. So this is going to be a very rare situation where it's going to be in the city of Richmond. It's going to only be if you can't otherwise determine where venue should be, where the call was received or sent.
Mr. Chairman, I would just say to that, it's hard to come up with an idea that you would prosecute something where, again, if it's where it originates or where it was received, if those 2 can't be determined, well, then the question is how did anybody know that there was a harassment claim in the first place?
But how do we know where the person doing the harassing is at the time they're doing it?
Well, it could be either or. So like if I don't know I've been harassed, Mr. Chairman, well, then I'm not bringing forth a claim that I was harassed.
We've got a motion to report. All in favor, vote green.
Ayes 8, noes 7.
Okay, you got a bill reported. Friday, is that your?
Thank you very much, Mr. Chairman. That's all for me.
Okay.
I'm going to leave while I'm ahead.
Next on the list is Delegate Rome.
Good morning, Mr. Chairman, members of the committee. This is HB 634. The bill that's in front of you is a substitute version of what we had introduced in the House. This one is basically just a Section 1 study.
And this is identical to
No.
It was part of 511, right?
So, Mr. Chairman, members of the committee, what I would say is on that is that I believe the bill you might have been referring to is what, SB 514, the one from Senator McPike.
That's it.
So Senator McPike's bill was an omnibus version of the 4 pieces of legislation that we had actually introduced. And the substitute version that left the House basically took the one part about visitation and in terms of how many times a guardian needs to visit their ward in a given year. The JLARC recommendation for that was once every 90 days. And so what instead came up was there was a concern about workforce issues on the House side. And so we have a Section 1 substitute on this that basically says that we will study the Section 1, or we will study the workforce issue over the next year. And basically by December 1st this year, they have to report back. And based on that report, we'll file a bill next year to deal with the issue.
Okay, this is a piece of Senate Bill 514, Senator McPike's bill on social services, I guess, or on guardianship. Does everybody understand? Second. Okay, got a motion and a second, or the substitute motions. Motion and a second to report, a green vote is a vote to report. Is that your only bill, delegate?
Yeah, that's my only
Okay,
bill.
thank you very much.
Ayes 15, no 0.
Delegate March.
Thank you, Mr. Chairman. Speaking to House Bill 509, this bill would amend the Code of Virginia relating to seizure of firearms and repeal removal from persons accused without due process of being a substantial risk. Who among us is such an expert on reading someone's mind that we can predict who will commit a crime even before they commit one? And how does one prove that a crime was prevented when no crime has actually occurred? We are depriving people of liberty and property for accused thought crime. This isn't proactive policing. This is a bad law to deprive Virginians of their rights.
Delegate March, this repeals the red flag law that we put in place just 2 years ago. Is that correct?
Correct.
Okay. And I think everybody up here understands that we were all here at that time. Are there people that need to be heard on this issue?
Mr. Chairman, there's also 4 hands raised online.
Okay, 2 minutes on each side. People in favor of the bill.
Mr. Chair, Philip Van Cleve, VCDL. Yeah, we support this bill. Not only does it violate Title II of the ADA, because if somebody is making a threat against themselves, the ADA says that's not a crime. That's something that shouldn't be villainized. It's something that they need treatment for. And so that's a problem with the bill as it stands. Not only that, Rand Corporation in 2020 did a study on all this. Does these red flag laws protect somebody that's going to commit suicide? And they could not come up with anything that showed it had any effect on suicide, which then the ADA rules that out. Thank you.
Okay, thank you, sir.
Good morning, Mr. Chair, members of the committee. I'm Patricia Webb, Virginia Citizens Defense League. Not only does this law that was passed 2 years ago violate so many portions of the Constitution and the Bill of Rights, it also neglects to get help for the person that desperately needs it. It's also been shown that even if it does temporarily stop a suicide, it doesn't prevent someone from later going on and committing suicide because it doesn't get them the help that they need. There are already provisions in place for taking somebody off the streets that is shown to be mentally unstable and a danger to themselves or others. Please repeal this bill and reinstate our constitutional and God-given rights.
Ma'am,
Thank you.
and you understand that if someone is TDO'd involuntarily, they lose their rights their gun rights until a court orders them to be restored. Could be indefinitely.
Understood.
Okay.
And they also lose their rights under this bill, but they lose a lot more rights.
Okay, thank you, ma'am.
Thank you.
Yes. Okay, we've got about 20 seconds left.
Morning, Mr. Chairman, members of the committee, DJ Spiker, National Rifle Association. Our members strongly oppose this bill. Excuse me, the principle, we absolutely support the bill, support the repeal of this bill, Senator Stanley, and thank you, the PHA, for bringing it. Thanks.
Okay, there are people online, you've got 7 seconds left. I'd ask you just to identify yourself, any group you represent, and just say whether you're for or against. And I assume that longest the people is for.
I'm Wally Bunya. I'm a retired Army colonel. I think the thing that sets America apart from all other
We don't
nations
have, just say
is
whether
our
you're
Bill of
for or
Rights.
against.
It protects us from unreasonable search and seizure and enshrines our right to due process. So vote to repeal that red flag law.
Okay, thank you, sir. Yes.
Yes, it's Stephen Anders, Chris Anders, Director of Virginia Constitutional Conservatives. We support this bill, which we refer to
thank
as
you,
the
sir.
Civil Rights Restoration.
Next.
Yeah. Vic Nichols, move to report, please. Thank you.
Thank you, ma'am. Yes. Next.
Catherine Schultz, would you please unmute?
Yes. Hi, can you hear me?
Please just identify
Okay.
yourself. Tell us whether you represent a group.
I'm Catherine Schultz. I'm Assistant State Director of the DC Project Virginia Chapter and Second Monday Constitution Group Board Member, and I am in support of the repeal of red flag laws.
Okay, thank you, ma'am. Next.
Tanya Shart, would you please unmute?
Good morning, Tanya Shart from Brady in opposition to this bill. Thank you so much.
Alicia Vaught, would you please unmute? Alicia Vaught, would you please unmute?
Alicia Vaught, founder, president of Second Monday Constitution Group. I'm here in support of 509. Please repeal this.
Okay, thank you, ma'am. Next.
Susan Peters, would you please unmute? Susan Peters, would you please unmute? Justin Griffith, would you please unmute?
Justin Griffith, Commonwealth's Attorney, Pulaski County. We support Delegate March's efforts today.
Okay, thank you.
Alan Getz Jr., please unmute. Alan Getz Jr., please unmute.
There we go. Yes, my name's Alan Guest Jr. I'm a 10th generation Virginian and would like to see 509 supported. Thank you.
Okay, thank you, sir. Okay, those opposed.
Good morning. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence. This bill is working. Virginia State Police report that it's being judiciously used. It is not being overused, and it's not being used in inappropriate ways. The concept of protective orders has been vetted in the courts. The concept of risk orders has been vetted in the courts. It's been upheld to be constitutional. In Virginia, in the last year and a half, counties and jurisdictions that have used the risk order include Campbell, Clark, Dinwiddie, Fairfax, Floyd, Fluvanna, Gloucester, Hanover, Henrico, Isle of Wight, James City County, Loudoun County, Montgomery, Patrick County, Prince William County, Rockbridge, Scott County, Tazewell, Washington, Wythe, and York, and a number of cities. These are being used carefully and selectively by law enforcement when they have no choice but to remove a firearm, and it's removed temporarily. This gives the individual his firearm back after 6 months. It's a good law. It is narrowly applied, and it is, in fact, saving lives. I'm personally aware of a mass violence workplace shooting that was prevented by using this law. Thank you very much.
Thank you, ma'am. Anybody else? The bill is before the committee.
Mr. Chair, could I ask the patron a question?
Excuse me?
May I ask the patron a
Senator
question?
Morrissey.
Delegate March, what is the position on VECA to a potential law that would repeal Commonwealth attorneys' rights to seek an emergency substantial risk order?
I'm not aware.
Final question.
Senator Morrissey.
You realize this is a situation where often a family member, realizing that a loved one is in jeopardy of harming themselves or others, and is calling in to the Commonwealth's attorney or to the police, and that it has the potential to save that person's lives. You realize that, right?
And we still have the ECO, the TDO. That's still an opportunity.
That's a permanent
This is
removal
just,
of a firearm. From a
correct. This is just personal property seizure.
This is just a 6-month removal.
Okay, thank you.
TDO, ECO, is a permanent removal.
Correct.
Without a hearing.
Mr. Chairman.
The bill, Senator Stanley.
Very quickly. Mr. Chairman, just like before, I'm going to say this. Anytime my government says that they are violating my constitutional rights of due process carefully and judiciously, I've got a problem, and we all should have a problem. And I support this bill.
Okay, the bill's before the committee. Got a motion and a second to report. Substitute motion. What? Okay, so that's been seconded. Substitute motion takes precedence. Vote green if you want a PBI.
Ayes 9, no 6.
Okay, thank you. Do you have another bill?
Thank you. No, sir.
Okay, the next person on the list is Delegate Wilt. And I think you have a bill, and Delegate, you're carrying one for Delegate Runyon as well. Is that correct?
That's correct, Mr. Chairman.
Okay.
Would you like to hear my bill first, Mr. Chairman?
Whatever order you want, it's fine with me.
Okay, thank you, Mr. Chairman. We'll look at House Bill 827. Basically, what it does, it repeals the code back to what it was before the 2020 session, as far as localities being able to control where firearms are allowed to be.
So in 2027, we passed legislation to allow localities to hold public hearings and enact ordinances that remove guns from different events and from different public buildings and parks and things like that.
Correct.
And this just undoes that.
Yes, correct. Also, I would say, Mr. Chairman, so looking at a little history, that was originally enacted back in the 80s because the state had a hodgepodge of these rules, locality. And the underlying issue here is any one of our citizens exercising their Second Amendment rights runs a chance of being afoul of the law depending on what locality boundary they cross. And so that's why it was enacted then, and that's still a concern today. Also, Mr. Chairman, committee members, the bill eliminates the requirement to destroy firearms that are confiscated and rather allows them to be sold through a proper licensed dealer. And it also prohibits firearm manufacturers from being sued. Now, a couple things that I want to make clear, Mr. Chairman, is this still doesn't mess with the firearms in the courthouse. That's still, that ban still stands. And also, when we talk about the localities can still have firearm bans in their building, in their places of work, where we're not touching that. So that's the bill, Mr. Chairman.
Mr. Chairman. Surville.
Senator Surville.
Question for the patron. You realize this was my bill that you're trying to repeal and you're wearing a JMU tie.
So you're going to move to report?
Are there serious questions? Well, Senator Morrison.
Delegate, a common mantra among the Republican Party and Libertarian Party is that those closest to the govern best. Do you agree with that?
By and large, yes.
Why should we change that and why don't we let Pulaski County and Campbell County and Wise County and Richmond City, who are closest to the governed, their local city council or board of supervisors, make those decisions? They are closest to the governed. Let them govern. This bill is the antithesis of that. Why should I vote for your bill?
Mr. Chairman, I would answer the senator that in the same token, we're a Dillon rule state. And we're charged to oversee broader issues, to bring, a harmony, a levelness across all areas, localities of the state, that we don't put all of our citizens in potential harm's way, making them a criminal just by crossing a locality. That's.
Thank you, Delegate.
Yes, thank you.
Okay, 2 minutes aside, are there people that need to be heard on this bill?
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
Okay.
It's Philip Van Cleve, VCDL. Yeah, the current law has got a lot of problems with it. How do you know if somebody should have had a permit when you're walking down the street in these localities that have passed this? How do you know? How do you know if there is a permitted event going on? It also affects adjacent properties. So you're sitting at a barber shop and the street next to you has a parade. Now suddenly in that barber shop, because it's open to the public, you can't have firearms. The owner of the barber shop can't have firearms. Parks, how do you secure parks? I mean, the police all admit they can't secure a park, but yet we've taken away even a permit holder's ability to carry in a park. This needs to be uniform because it's a civil right to be able to protect yourself. It's a basic civil right. It shouldn't be divvied up at local level. Thank you. We support this bill.
And I appreciate that. And I apologize, but I didn't realize Senator Chase had the identical bill during the House. I apologize. I wouldn't otherwise spend much time on this in terms of a public hearing. But I recognize the people that are for it. I recognize the people that are against it. And there are a number of people that signed up online to speak in for it, but we've already heard this bill, Senate Bill 74. So is there a motion on the bill? Got a substitute motion. What's that? Substitute motion takes precedence. Please open the roll. Vote green is a vote to PBI. Substitute to PBI.
Ayes 9, noes 6.
And I apologize about putting you through that. I just didn't see the note about Senator Chase's bill.
Thank you, Mr. Chairman. Minds could have changed.
You could tell I wasn't really paying much attention. I'm sorry.
Yeah, so Mr. Chairman, also, and I appreciate your acknowledgement, hopefully before you have House Bill 1000, deals with civilian oversight bodies. Mr. Chairman, committee members, please understand, what this measure does, it does not take away civilian oversight bodies. It tries to put a couple modest guardrails on the bodies. It requires all appointed members to observe law enforcement employed with the locality for a total of 24 hours within 90 days of their appointment. That just, if they're gonna deal with law enforcement issues, the thought is they should at least have a little bit of experience with a law enforcement officer. It also it allows those bodies making disciplinary determinations up to and including termination, but the law enforcement agency may decline to implement the recommendation, but they would be required to make their reasoning public record within 30 days. Mr. Chairman, committee member, this is a sunlight issue. This, it still puts it back and holds the law enforcement agency responsible. So I would say if they've got a true bad actor, and the board and the citizen review body looks at that, determines that, and then they ignore the law enforcement agency ignores that. I mean that's going to be a real stain on them. Third, it requires every board and locality to have at least one retired member of law enforcement appointed to that oversight body. But let's say if it's Richmond can't have a Richmond law enforcement officer or someone that is retired from Richmond. It would have to be from another locality.
Okay, I think everybody understands the bill and the changes that were made to the 2020 legislation.
Mr. Chairman, I had a question
Benjamin.
concerning line 100, which requires a ride-along program. I don't know, and my question is whether ride-along programs typically require a waiver of liability by the person riding along with the officer. And if it does require a waiver of liability, I wonder whether this law is going to work. If you're requiring somebody to ride along, but you also require that they waive any liability if they're injured or killed, that's the question I had. Mr. Chairman, there's something called sovereign immunity that provides that liability waiver.
Okay, are there additional questions for Delegate Wilt? Are there people that want to speak in favor of this legislation? Well, 2 minutes aside. We've not heard this bill before, so 2 minutes aside.
Mr. Chairman, members of the committee, Sean McGowan, Virginia Police Benevolent Association, we support this bill.
Okay, thank you very much.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, we do have one hand raised.
Okay.
Dominique Martin, would you please unmute and begin your testimony?
Don't think he's in favor.
That is correct, Mr. Chair. I was planning to speak in opposition. Is this the appropriate time?
I guess now's the appropriate time.
All right, thank you, Mr. Chair, members of the committee. Dominique Martin, New Virginia Majority. The legislation that was passed 2 years ago was enabling legislation, and what we've seen over the past 2 years is communities coming together with stakeholders, community input, and law enforcement to negotiate what the terms of their own civilian oversight boards would be. And so we would appreciate that we keep it that way. If a certain locality decided that what was proposed in this legislation was the best avenue for their locality, they surely could do so. And so we hope that you would oppose this bill and keep the legislation as it was passed a few years ago.
Thank you very much. For the bills before the committee.
Move to report. Second.
Got a motion to report?
PBI.
Okay, so a motion to PBI. It's been made by 3 people, so I guess it's been seconded. So the substitute motion takes precedence. All in favor of the substitute motion, vote green.
Ayes 9, no 6.
Okay, thank you, Delegate Runyon and Wilt.
Thank you, Mr. Chairman, committee members.
Okay, Delegate Campbell, you've been sitting there a long time.
Thank you, Mr. Chairman. I have, House Bill 79, which is a reenactment of the equipment violations that were repealed 2 years ago. And could someone pass these out for me? What's being passed out to you is something I think some people on the queue are going to be speaking about in a little bit. And basically, I want to start off by, I'm going to read you a list of names. Randy Kraft, William Cerf, Theodore Bundy, David Bersikowitz, Joe Rufkin, Timothy McVeigh, Wayne Williams, Bruce Davis, Larry Eller, James Swan. Some of you might have recognized a couple of these names, but these are all serial killers that were caught in routine traffic infractions. And that is the importance of allowing police officers to have things that they can stop vehicles for in the nature of equipment violations. Let's talk about a couple of these people real quick. Timothy McVeigh, he blew up the Oklahoma City government building, the federal building. A couple of minutes after that, he was stopped on the interstate by an Oklahoma State trooper for a registration problem. Theodore Bundy, Ted Bundy, as he's referred to, was probably one of the more notorious out of the group. And he was a slippery little sucker. He escaped 2 times, but he got caught 3 times in traffic violations. So as you can see, this concept of allowing police to stop people goes further than just writing somebody a ticket to meet what we think is a quota. It's actually something that is very important.
Now, the legislation basically just repeals what the changes we made in 2020 about traffic stops, but doesn't repeal marijuana odor.
It has nothing to do with marijuana. This is totally a safety bill.
Okay.
Now,
I got a question.
Senator Sasslaw.
Yeah, I'm just curious. And by the way, I'm just totally in favor of them executing Timothy McVeigh. But the question that I have is this. How would stopping him for a speeding ticket or running a red light have stopped him from blowing up that building?
actually, a couple of them, they actually caught bodies in the car with them when they stopped them.
They what?
They actually caught dead people in the car with them. One of them I remember reading about, he had stopped his vehicle to dispose of a body and got a parking ticket put on it.
What he's saying, Dick, is that McVeigh was stopped by, he was caught for a traffic violation.
After he did it.
Yeah.
After he did it.
But these are mass murderers who were continuing their strings of murders. Son of Sam, he wasn't going to stop until his car was picked up on a parking ticket. They caught him.
Now, I have one that everybody would recognize, but I didn't add him to the list because I don't know Maryland law. But that was John Allen Muhammad, the D.C. sniper. They were caught in a rest area in Maryland before he was transferred to Virginia, which was the end of him. Now,
They were hunting for them. They were on the lookout for them.
they were on the lookout for him, yes.
They pulled
That's
them
why I
up,
said
they
I did not
recognized
include
them,
it in
pulled
the
them over.
list.
And they're not
Okay,
prevented.
okay, no running debate.
Yeah,
Come-
they're not
No,
prevented though.
he was still in the car sleeping in a rest area.
okay.
But when I worked in my previous employment, one of the jobs I did commercial vehicle inspections. And one of the things that I had to do was I would have to go out with tractor trailer trucks that were involved in fatal accidents. I would have to investigate that accident to determine what caused it. And basically, some of the accidents that I want to point out to y'all is where a car comes up on a tractor trailer truck, does not realize that the truck is going slower or that he's stopping, and the car literally runs in under the trailer. Another accident with tractor trailer trucks involving cars is where the car doesn't have brake lights or tail lights. The truck driver, same thing, doesn't realize they're running slower or that they have stopped for some reason, and he literally runs over top of them. Now, these accidents, and I don't know how many of them I have gone to in my career, but they're very gross, and I hope none of you have ever seen one of them. But it goes back to equipment violations and things that police officers need in order to enforce the law. Not only are they writing you let's just say the tag light, because I think that's probably the one that people hate more than anything. But when you have a vehicle in a certain place and you know it's not right, and you see him leave, let's say an industrial complex, you see him leave and it's 3 o'clock in the morning, you start looking for a reason to stop him. And if it happens to be a tag light, that's what you stop him for. The Supreme Court has issued rulings on traffic stops and how police can and cannot stop vehicles. And they operate by those rulings. I know in the state police, we had a manual that was about 3 inches thick of Supreme Court rulings. So we were very conscious of what this Supreme Court said in our traffic enforcement. But with what we have done here, the police feel like that they can't stop people for any type of violation, and most of them have pretty much pulled back. I have, my sheriffs have been complaining to me, telling me that, well, one sheriff in particular told me, he said, I know who's stealing the catalytic converters, but we see him leaving the areas. We never see him stealing the catalytic converter, and we have no way of stopping him because we can't find something. So, you know, this is what I'm talking about. I'm not going to drag this out. I know you're in a hurry, and I've got a lot more I could add to it. There's some people in the queue that want to talk about a particular wreck a couple of weeks ago, I think.
We get the gist of it. 2 minutes aside for people that are for, people that are against.
For those
Mr.
attendees
Chairman, Wayne Huggins, State Police Association, we very much support this. We've heard an awful lot this session about homicide, how the homicide rate is increasing in Virginia, well over 500 homicides last year. There were well over 900 traffic fatalities last year. It's approaching 1,000. I just wish I would hear as much public outcry about highway safety as we do crime, because having delivered many death messages, the manner of death leaves little comfort to the survivors who are left over. Please, let's take highway safety serious. Thank you.
Thank you, sir. Okay, who's next? We have people online.
For those attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we do have some hands raised.
Okay, you've got about 1:20.
Ray Clemens, would you please unmute and begin your testimony? Ray Clemens, would you please unmute and begin your testimony? Ray Clemens, this is your last call to unmute and begin your testimony. Brad Haywood, would you please unmute and begin your testimony?
He's not for it.
Ann Taylor Callum, would you please unmute and begin your testimony?
Oh, this is Brad Haywood. Can I speak still? Sorry.
Are you for or against?
Against the repeal.
Okay, put him in the opposition column, please. And call on him when the time comes.
Ann Taylor Callum, would you please unmute and begin your testimony? Brad Haywood, would you please unmute and begin your testimony?
Oh, I was just speaking, but what I was going to say is I was just going to list a few more names, which are Samuel DeBose, Sandra Bland, Philando Castile, Walter Scott, and Dante Wright. Those are all people who would be alive today if Virginia's historic laws limiting pretextual policing were in place nationwide. You'd think if this had these changes had some legitimate impact on public safety, we'd have scary real-life data or anecdotes about traffic accidents or something, but instead we're hearing that this is a serial killer prevention law. The real impact of pretextual policing is that Black people are pulled over nearly twice as often as white people, and that's what this bill was meant to address, and it's doing a good job of that. We ask you to oppose HB 79.
Mr. Chairman, those are all the hands raised online at this time.
Okay, the bill is before the committee. Are there motions?
Move the over PBI.
Second.
Got a motion to report and a second. Got a motion to PBI and a second. And that substitute motion takes precedence. Open the roll. A green vote is a vote to PBI.
Ayes 9, no 6.
Thank you, Delegate. Delegate Davis.
Thank you, Mr. Chairman.
House Bill 70, right?
Yes, sir. Thank you, Mr. Chairman. House Bill 70 deals with the Procedural Guarantee Act. Essentially, it just provides the baseline of procedural guarantees and due process for our local law enforcement officers as it does for our other law enforcement officers outlined in 9.1-501 through 506.
Okay, it strikes paragraph B that was adopted in 2020.
Yes, sir.
Is that correct?
Yes, sir.
Okay, so this just means that the Procedural Guarantee Law Act would apply where there's a law enforcement civilian oversight board.
Yes, sir. It provides that minimum set of procedural guarantees for our local law enforcement officers.
Okay. Does everybody understand it, or are there any questions from the committee? People that would like to, I'm sorry, Senator Obenshain.
I think I had asked before, what are the differences between the local and the state procedural guarantees?
So the minimum guarantees are pretty significant, and I could go through them, but I got the expert behind me, and he'd probably be more articulate with it if that would be okay.
Mr. Chairman, Senator Obenshain, Sean McGowan with Virginia Police Benevolent Association. The grievance process is the state in 9.1, they are bare minimum standards. The localities can have better due process in place. The lawyers that we employ pick which system is best depending on the circumstances of the case. So I can't say exactly what the differences are between the two systems because the localities can adopt their own system.
Mr. Chairman.
Senator Obenshain.
Mr. McGowan and I spoke before, but am I correct that the citizen review panels, and this is I think a big flaw with the citizen review panel legislation that we adopted, but am I correct in understanding that they have the power to terminate? And if so, is there even an appeal from that?
Yes, sir. Under the current law, the way I understand it, it goes, the person who's terminated could appeal for a hearing. What we're trying to do is to bring the due process back into consideration. This doesn't diminish the Citizen Review Board. It only allows for that due process. And I'm told that it does not, that putting this language back in does not impact the function and purpose of the Citizen Review Board.
So,
Senator Obenshain. Are there other questions? Senator Morrissey.
Good morning, Delegate.
Morning.
Are there any civilian review boards now that provide rights that are less than the law enforcement officer's procedural guarantee rights?
The problem I would tell the senator is that the rights can change in localities because there is no minimum floor. This would reset that minimum floor with everything from 501 to .505. It's things like notice of charges, the hearing panel recommendation itself, immediate suspension. A whole bunch of those things are no longer immediate or minimum floors for our local law enforcement officers like they are for all of our other law enforcement officers. So I would say that right now the local governments can have lower floors if they so desire because there's a minimum floor in place.
Are there additional questions for the are there?
Mr. Chair.
Senator Boysko.
So when I look at the code around the civilian oversight bodies, it appears to me that it is the locality's choice whether or not they want to adhere to that. Have you heard significant backlash from localities that have already started implementing that? And can you give specific examples of where this has been misused or inappropriately punishing someone who can you share any examples of where this is not, because this is a brand new policy as far as I'm understanding.
Sure. I can say that I've heard significant concern that it could be a problem, but I'd rather defer to.
Yes, Mr. Chairman, Senator Boysko, we have not had cases where we've had to step in and try to rectify this problem, but we see it as a very potential problem as more and more citizen review boards are put in place.
Mr. McGowan, how many citizen review boards are there?
That I do not know, Senator.
How many are there?
Mr. Chair,
Senator Peters.
let me ask a question. I voted for, and I think I know we passed collective bargaining at the local level. And so if a police union is formed and they collectively bargain with the locality and say, we're going to have certain rights if we're under a civilian review panel, maybe the right to access to counsel, maybe the right to, some type of notice if they're being investigated. Wouldn't that basically supersede what we're doing here? I mean, don't they have the ability to effectively protect themselves?
Well, I would say, Senator, they don't. So that was a local option bill for the collective bargaining. So not every locality very few localities have moved forward on that. So that would not be a protection in place at this particular time for so many.
Follow-up question.
And isn't it true that very few localities have followed up with CRB?
Right, I was going to say, and that's also a local option, so.
Right, but I can speak to one because my city has a citizen review board, but does not have collective bargaining. So I can speak to one that we have that disparity.
Are there other people in the public? Did we hear from everybody?
Mr. Chairman, there's 2 hands raised online. I'm not sure if they're in support or opposition.
Okay, just briefly, if you just tell us what your views are.
Vic Nichols, would you please unmute and begin your testimony? Vic Nichols, would you please unmute and begin your testimony? Vic Nichols, this is your last call.
Thank you. I just got on. If we give criminals due process, then we should give the same fairness to police officers and, by the way, legitimate gun owners. Please move to report the bill. Thank you.
Teresa Helpler, would you please unmute and begin your testimony? Teresa Hepler?
Yes, hi. Hi, Teresa Hepler with the Legal Aid Justice Center, and we are in opposition to this bill. I first want to just highlight that based on some of the comments I've heard, officers are able to avail themselves of their due process rights under the current enabling legislation in areas that have binding disciplinary determinations. They can avail themselves of the municipal grievance procedure. So the municipal grievance procedure, I just want to highlight that, is available to officers who are subject to the binding disciplinary recommendations of oversight boards. I would further note that the Law Enforcement Officer Procedural Guarantees Act is incompatible with oversight boards right now, as it provides a mechanism for law enforcement to circumvent the oversight board's investigation and disciplinary recommendation. And it allows them to have their misconduct investigated and disciplined by fellow officers, which is something the enabling legislation sought to prevent. So for these reasons, we oppose HB 70.
Mrs. Chairman, we have one more hand raised. Dominique Martin, would you please unmute and begin your testimony?
Mr. Martin, please be brief.
Yes, sir. Dominic Martin, New Virginia Majority. For the reasons previously stated, we also oppose the bill.
Okay, thank you very much. The bill is before the committee. Got a motion to report. And a second. Move to PBI. And a motion to PBI, substitute motion. Is that seconded? That's seconded. Okay. Substitute motion takes precedence. A green vote is a vote to PBI.
Ayes 9, no 6.
Okay, thank you.
Thank you, Mr. Chairman.
Senator Davis, our Delegate Davis. Delegate Waxman, you're next. Waxman, I apologize. Is it wax or wax or?
No apologies necessary. I make it easy. It's pronounced like Waxman, Waxman. We're
Okay.
quite used to that. Mr. Chair, members of the Judiciary Senate Committee, it's my pleasure to be here today. I'm going to be discussing House Bill 204. 204 is another piece of gun legislation. It rolls back the number of days required for a background check for a firearm purchase from 5 back to 3, like it was back up till 2020. In 2020, it was a record number of gun transfers. It was approximately 475,000 firearms that were transferred that year. It turned out that there were absolutely no need for any retrievals, that it passed the 3-day period of time, and the bill merely just changes the word 5 in 2 places back to 3.
Okay, I think we get it. This just reverses legislation we passed in 2020. We didn't have a similar bill on the Senate side. Unless there are questions for the patron, there are 2 minutes aside. So people that are for the bill have 2 minutes, and then people opposed have 2 minutes.
For those attendees in the Zoom room who'd like to speak in support of the bill, please raise your hand electronically now.
Good morning, Mr. Chairman. DJ Spiker, National Rifle Association. We absolutely support this bill. This bill was passed last year. It is a solution in search of a problem. This bill was not necessary. The patron, when he brought it, could not cite an example of this bill needing to be passed. He cited other states, including South Carolina, where other incidents happened. The opponents of this bill are going to note what an incredible system Virginia has, the background check system as a point of contact state. That applies here as well. This is an unnecessary bill. Bring it back to 3 days, bring us back in line with federal law. We absolutely support that. Thank you.
Okay, thank you, sir.
Good morning again, Mr. Chair, members of the committee. Patricia Webb, Virginia Citizens Defense League. I'm also a licensed FFL, so I can speak directly to this bill. In reality, it's not 3 days or 5 days, it's business days. So before this bill was passed last year, at Christmas and New Year's, it was actually 12 days before a gun could be transferred without state police approval, not 3. So that's a huge difference because they're not counting non-business days. It would not have made a difference in South Carolina whether it was 3 days or 5 days or a month, because they did not find out that this person had mental problems because it wasn't reported into the system. So it was an after the fact that they found out. I will also say that you're delaying somebody's rights here. So, and as a licensed dealer, if I have a delay that goes past the time, I have the ability, and it's recommended, that I call the state police and find out if they recommend approval of that transfer or not. And it's at my discretion whether I transfer that firearm without approval. So thank you for your time.
Thank you. We have less than 5 seconds. Please just
No problem.
identify yourself. And
Philip Van Cleve, VCDL, we support.
okay, thank you. And I assume you're opposed, right?
Correct.
Are there people online that are in favor of this legislation?
Mr. Chairman, there are no hands raised.
Okay, 2 minutes opposition.
Yes,
please.
good morning. Lori House with the Coalition to Stop Gun Violence. We oppose the bill. Virginia State Police do a good job, and they do not need their hands tied in a way that shortens the process to ferret out persons whose records are complicated and need ferreting out, i.e. most background checks occur in 30 seconds. When it doesn't, it's because there's a complication. Somebody's under arrest, they're a fugitive, they're from out of state, there's a problem. And Virginia State Police need a time to ferret out that problem and make an actual determination on the eligibility of the buyer. Let's please not tie state police hands and let them do their job. We oppose the bill.
Thank you.
Mr. Chairman, members of the committee, Andrew Goddard, Virginia Centre for Public Safety. These 5 days would only apply to people with a very spotty record, some record that needs to be given extreme care and attention. The simple answer is keep your nose clean and you can get your firearm in 5 seconds.
Okay, are there others?
Mr. Chairman, there are 2 people online, I believe, that are opposed to this bill.
Okay, you've got less than a minute.
John Calhoun, would you please unmute? John Calhoun, would you please unmute and begin your testimony? Tanya Shart, would you please unmute and begin your testimony?
Hi there, Tanya Shart speaking in opposition to the bill. A vast majority of background checks are completed in under a minute, but in the rare occurrence that they need more time, this bill will remove the valuable time from the Virginia State Police to complete a thorough and comprehensive background check. This is common sense. We respectfully urge you to vote no.
Okay, thank you.
Mr. Chairman, those are all the hands raised.
Okay, the bill's before the committee. I think we understand it. Are there motions?
Second.
Motion. Well, a substitute motion. Got a motion to report, a substitute motion to PBI, both been seconded. Substitute motion takes precedence, a green vote is a vote to PBI.
Ayes 9, no 6.
Okay, thank you, Delegate.
Thank you for your work today, gentlemen, and Madam Secretary.
Next is Delegate Hope.
Thank you, Mr. Chairman, members of the committee. I have House Bill 677, and I do have a line amendment that I'd like reported. That line amendment is a delayed enactment to July of 2024.
Yes, Mr. Chair. So it's after line 21, insert that the provisions of this act shall become effective on July 1, 2024 is the amendment.
Okay, we've got the amendment, it's been moved, and is there a second? Okay, I'm all in favor of the amendment, say aye. Aye. Opposed? Okay, the bill's been amended. I understand this is a Boyd Graves bill. And it simply allows the posting, in terms of a notice, posting on the courthouse or government website.
That's true, Mr. Chairman. It requires that they do both, and this gives the 2-year delayed effective date, gives the clerks that don't have the website up time to get the website up. With that amendment, I'm not aware of any opposition.
It doesn't change any posting that has to occur right now in their existing law, does it?
Well, under current law, you can do either the courthouse or the website. The recommendation of Boyd Graves was to do both.
Do both, okay. Motion to report in a second. Is there anybody that feels it's necessary to speak to this bill? Okay, we've got a motion to report. All in favor, vote green. Okay, thank you, Delegate Hope.
Thank you, Mr. Chairman.
McGuire.
Thank you, Mr. Chair, members of the committee. House Bill 108 goes after drug dealers, those that distribute or sell fentanyl and other Class 1, Schedule 1, Schedule 2 drugs that are killing folks. As you all know, everyone in this room knows that we have a fatal overdose epidemic in our country and in Virginia. And federal law allows those selling drugs resulting in fatal overdoses to be charged with a homicide. But under Virginia's current law, drug distributors can't be charged with homicide for selling drugs that result in a fatal overdose. Now, this was a good bill in 2019. It passed the Senate 40-0. And it's even better bill now with COVID-19 and everything like that. Fatal overdoses in Virginia have overdosed. And if you look just 5 seconds on Google, you'll find out that Richmond is the epicenter of the fatal overdose epidemic that's going on in our Commonwealth right now. If the government should do anything, it should be to protect our people. I've visited with 7 families throughout the Commonwealth where their son or daughters, 18, 19, 20 years old, has overdosed and died. And some of them in very wealthy homes, and some of them were in trailer courts. It's a real big deal. I spoke with Sheriff Creasy Goochland, Sheriff Carl Leonard in Chesterfield, Sheriff Nunnally in Powhatan, Sheriff Lowe in Louisa County, and Sheriff Hines in Hanover County, and they all agree that the number one killer, the fatal overdose, number one killer in their counties, and I think you would find this across the Commonwealth, is fentanyl and other Schedule 1 and 2 drugs. So this doesn't go after someone who's doing drugs with their friend in a room. This goes after those that distribute or sell the drugs. And again, this is something that we do at the federal level, and it passed the Senate 40-0, and I hope that this committee would pass it.
Mr. Chairman.
Senator Edwards.
The bill that passed in 2019, though, required distribution to be the proximate cause of the person's death. This is not the case here, is it?
You know, I would refer to counsel on that, because when I presented this bill, I was told it was the same bill. Maybe just a little bit of a change as far as word to make the lines the same.
Mr. Chair, you're correct. The bill in 2019 had language that specifically stated that the death needed to be the proximate cause of the drugs.
Mr. Chair.
Senator Peters.
This may be a question to my friend Senator Benjamin, but if felony murder rule is if you commit a felony and a murder, or excuse me, a death results, then you're guilty of felony murder. Does that typically apply in situations of drug distribution?
It would. It depends on the circumstances, Mr. Chairman, Senator Peterson. Felony murder requires that the death result while in the prosecution of a felony. The term "while in the prosecution of a felony" means there must be three elements. It must be at the same time, in the same place, and there must be a causal connection.
Okay, so further question, just to be more precise. Let's say back in 1986, someone sold 2 grams of cocaine to somebody at University of Maryland, and then that was later material to the death of Len Bias, which happened from a cocaine overdose. That would not be a felony murder because there's no contemporaneous event.
Mr. Chairman, that's correct.
Okay.
I know of a situation in Allegheny County just within the last 2 months where a felony murder conviction was obtained, where there was a Schedule I or II substance involved, distribution. So I'm not sure this does anything that can't already happen. It just makes it a little more specific.
Mr. Chairman.
Chairman Edwards.
My understanding too is drug distribution, the maximum penalty is 40 years for the first offense, life for the second or subsequent offenses, and the judge can consider the fact that somebody died at sentencing as a factor. So I'm not sure we need the bill.
Okay, well, we haven't heard this bill before. We'll take 2 minutes for people in favor and 2 minutes for people against.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now.
Good morning, Mr. Chairman. My name is Nathan Green. I'm with the Commonwealth Attorney's Office in the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We are in support of this bill. Mr. Chairman, specifically to Chairman Deed's question, what can this do that we can't already do? Presently, if there is a distribution and the drug dealer stays in the hotel room and the two of them use the drugs that he just sold to him, the Commonwealth can go after that individual because it stays contemporaneous, it's the same time and the same place. However, if that drug dealer sells the drugs, gives them to him, and then leaves the hotel room, and the exact same thing happens, the individual shoots the drugs into his arm, and it was enough fentanyl to kill him, if the drug dealer has left the hotel room, we no longer have the location proximity, and so therefore those are the cases that we cannot get with the felony murder statute. We can get the individuals who stick around and do drugs with their friends. Those really aren't the ones that we're interested in. We're interested in those individuals who sell the drugs and then leave, and those drugs kill the individual. We do support this bill.
Thank you, sir.
Good morning. My name is Nicole Whitman. I'm here on behalf of the Attorney General's office, and for the exact reasons that my colleague, Mr. Green, stated, we would also support this bill. Thank you.
Thank you, ma'am. Are there others who would speak in favor of this legislation? Are there people online?
No, Mr. Chairman.
Are there people opposed to this legislation?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no hands raised in opposition.
Move to report. It has to go to finance, so the motion is to report and re-refer to finance. Okay.
PBI.
And substitute motion to PBI.
Second.
It's been seconded. The substitute motion takes precedence. A green vote is a vote to PBI.
Ayes 9, no 6.
Okay. Thank you, Delegate McGuire.
Thank you, Mr. Chairman, members of the committee.
Delegate Glass.
Good morning, Mr. Chair. So my bill, House Bill 1212, is a standalone bill that has a small technical amendment to align it with Senate Bill 514 from Senator McPike.
Senate Bill 1212, and that's also a piece of Senator McPike's bill.
Mr. Chairman, we have 4 technical amendments to conform it to the portion of the corresponding portion of Senator McPike's bill, which is Senate Bill 514, which reported unanimously from this committee.
Okay.
Move those amendments.
Second.
A motion and a second to approve the conforming amendments. All in favor, say aye. Aye. Okay, this is the part that requires notice of hearing for guardianship to include a notice that any adult, individual, or entity who appears of any name who appears in the initial petition may become a party by filing a pleading.
Yes, that's true, Mr. Chair.
Does everybody understand the bill? Are there motions?
Second.
Okay. The green votes a vote to report. Please. Okay, Delegate Glass, thank you.
Thank
Delegate
you, Mr.
Williams. Les, you're not signed up.
Oh, am I not signed up?
Yeah, you're next up.
Okay. No, it's fine. Hi, good morning. I'm here to present on HB 812. There's a simple substitute, but it effectively that I'm offering for your consideration,
Is there a
which
substitute for this bill?
it is, sir.
Okay.
And it's pretty simple.
Okay, motion and a second to adopt the substitute.
Mr. Chairman,
Senator Serville.
I'm sorry. I believe Senator Reeves had a bill that was similar to this. Is the substitute conforming it to Senator Reeves' bill?
I don't believe so. The substitute is, there's two sections that are very, very similar, and it makes it into one section. Section B is very similar to, if you look down, Section E, so we combine them.
Oh, different bill. I'm sorry, that's a different bill, Mr. Chairman.
Senator Reeves didn't have this bill.
Sorry, Mr. Chairman. It's a different bill.
This just repeals the bill I introduced last year.
Oh, I'm sorry,
Is that right?
Senator Deeds.
Not in support of this.
Okay.
Go figure, right?
Go figure. So we've got the substitute, and we've had a motion to adopt it and a second. Are everybody in favor of the substitute, say aye. Aye. Okay, we've got the substitute for us. Last year, we adopted legislation, did away with the presumptions against bail in all cases, and the substitute, I guess, does away with some of them, but not all of them.
That's right. It has the enumerated list in the bill. Mainly stems from violent felonies, second violations of protective orders, drug offenses, things like that. And then specifically, one thing that I'd highlight is we're having issues with human trafficking, and it's very difficult to find these people once they're released, and they never come back. So this bill would help with that as well.
I'm looking over on line 85, and you're aware that you all passed unanimously a bill from Delegate Lopez that did away with the use of the word aliens.
Yes, and I actually thought about that because I was like, should we conform this bill right now to that?
There might be another idea.
Yeah, you're just going to kill it. You're just going to kill it. That's fine. Well, I'd like you to hear from the folks on the online that support this bill.
Well, I think we understand the bill. This does away with this, reinstates the presumption in certain cases, certain enumerated cases. And if there are people in favor, let's give them 2 minutes.
For those attendees in the Zoom room who would like to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, we do have 2 hands raised at this time.
Okay.
Wyatt Rolla, would you please unmute and begin your testimony? Wyatt Rolla, would you please unmute and begin your testimony? Audrey Redmond, would you please unmute and begin your testimony?
Hi, good morning. My name is Audrey Redmond. I am Regina Redmond, Lola Brigitto's little sister. On September 19th, Regina was brutally murdered by her husband with a hammer. She was beaten so badly I could not recognize her when I arrived at the hospital. Peter Lola Brigitto was released on a $5,000 unsecured bond for an earlier attack that occurred in July 2021, where he strangled her, abducted her, and assaulted her. On September 19th, Peter violated a court order that stated he was to have no contact with my sister. Needless to say, on the afternoon of September 19th, Peter went to my sister's apartment and brutally beat her. Regina fought for her life for 7 days. Just 4 days shy of Regina's 45th birthday, the doctors informed our family that there was no longer any brain activity due to the severity of the injuries. Regina passed away September 26, 2021. This was an unnecessary act of violence that occurred, and my sister lost her life due to laws allowing criminals out of jail on unsecure bond. I would like to thank you for taking the time to listen to Regina's story and the consideration of laws being changed so that no other woman has to suffer from such a brutal attack as my sister did. Thank you very much for your time today.
Thank you, ma'am. Are there others?
Mr. Chairman, those are all the hands raised in
Okay, are there
support.
people opposed?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, we do have 2 hands raised.
Okay. Please let the opponent speak.
Dominique Martin, would you please unmute and begin your testimony?
Thank you, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority. We're opposed to this bill as it stands. There's still the cases to be made to not release those to bond who are of significant risk to the community, but we are opposed to the reinstatement of the presumptions against bail. Thank you.
Wyatt Rolla, would you please unmute and begin your testimony?
Good morning, Mr. Chairman, members of the committee. My name is Wyatt Rolla. I'm an attorney with Legal Aid Justice Center, and I'm also a member of the Pretrial Justice Coalition, which is composed of over 20 member organizations. We are opposed to HB 12. The 2021 repeal of the presumptions against bail was an example of criminal justice reform that can also be responsive to safety concerns for victims. Language was added to the code. 19.2 is where it's currently codified that instructs a judicial officer to consider specific factors when determining whether to admit an individual to bail. And the code was also amended in response to concerns from domestic violence and sexual violence advocates to specifically require the assessment of safety of family and household members in making bail determinations. These presumptions are not an effective mechanism to ensure public safety, and I would urge you to vote no on HB 812.
And Mr. Roll, isn't it true that the considerations that were put into the code didn't change substantive law, but they were in there for the first time for magistrates and judges to consider?
That's correct, Mr. Co-Chair. There were provisions in a different portion of the code that enumerated specific factors in determining the conditions of bail, but this actually moved into the section of code about determining whether to admit a person to bail. And that includes, again, we think rather than using offense proxies, we think it's a better practice to actually consider directly these public safety considerations.
Okay, thank you. And you want to be heard on this bill?
Yes,
please.
Sorry. Mr. Chairman, Rick Nagel, American Bail Coalition. We support the substitute. I believe line 70 will allow a judicial officer to release on a secured bail, thus preventing the increase in preventative detention. Thank you.
So this just requires secured bond in the event there is a bond?
Yes, Mr. Chairman.
Okay, thank you very much. Okay, the bill's before the committee. Are there motions? Got a motion to report?
Motion PBI.
Substitute motion to PBI, which has been seconded. Substitute motion takes precedence. A green vote is a vote to PBI. Okay, thank you, Delegate Williams.
Thank you all.
Delegate Adams, are you still out there?
He was here.
Delegate Adams left, okay?
Good morning, Mr. Chairman.
Senate Bill 760, is that correct?
Well, I have,
You have several?
I think there are two bills that are on the docket, 758 and 760. They both involve the probation violation situation. And if I may, on House Bill 750, if I can present that. If
760 or 758?
758, if that's please. Okay. And the reason I asked to address that first, that there is a substitute that council has prepared if the committee would wish to take that up.
Okay. Do we have the substitute?
Move the substitute.
Motion and a second to adopt the substitute. All in favor, say aye. Aye. Okay, the substitute's for the committee, but I haven't seen a copy of it yet.
Coming to you, Senator. Thank you, Mr. Chairman. The substitute and the bill in general is a reflection of many hours of conversation between stakeholders and folks who are involved in probation violations from the Commonwealth's attorney side and also the supervision side. I think it's also incorporated concerns that were raised from Indigent Defense Counsel. And it proposes to make amendments to the dramatic changes from last term of the General Assembly that implemented a series of technical violations, including almost everything in a description of technical violations. It would remove from that category of technical violations serious offenses like distribution of Schedule I or Schedule II drugs, absconding, possession of a firearm by a convicted felon, and would then give the court the discretion in those cases to adjust, modify the suspended period of a sentence. It retains, however, the rest of the language that is in place with regard to technical violations, so it limits the judge's authority, as the General Assembly has already done it in those other cases, but not for a second offense like it typically is now. A court on a second offense for any violation would be able to modify the sentence. So those are the major changes as presented here. And as I say, I think there's a great deal of consensus around this from sort of a global perspective. I know there are Commonwealth's attorneys from all factions of the association and other groups that would like to speak in favor of this.
Okay, are there questions from the committee for the patron?
Mr. Chairman.
Senator Servell, then Senator Morrissey.
Thank you, Mr. Chairman. I have a motion at the appropriate time, but this one was obviously subject to the discussions we referenced earlier, but I don't know when you want me to make it, but I'm happy to make it when you're ready. The motion, Your Honor, I would move to basically strike any of the changes that appear after line 86 and also strike Class 2 misdemeanor from the misdemeanor probation extension, and then also add a reenactment clause.
So the only new language that would remain in the bill would be on lines 82 and 83.
And on the first page.
And lines 22, 23, and 25.
Right. So basically, Mr. Chairman, what it would do is it would extend Class 1 misdemeanor probation 2 years and put a reenactment clause in the bill is basically what it would do. The amendment I propose.
Okay.
It puts a reenactment clause on it so we can talk about it some more.
Mr. Chairman, I don't believe there'd be anything left in the bill after.
Well, let's wait and hear the proponents and opponents. And Senator Morrissey, did you have something?
My question is now moot.
Okay.
No, my question of the patron, given your motion. You had a motion. Was it seconded?
No, I asked him to withhold it until we're finished.
All right, sure, then I have a quick question. Good morning, Delegate.
Good morning.
There's a reason they call it technical violation because it includes a violation that at the very least does not include a new conviction, correct?
Correct.
Tell me as succinctly as you can, why for a second violation, I think the law was up to 14 days, am I right? Was that
I believe that's correct, yes, sir.
Why should, for a technical violation, we now give the judge the authority to impose the entire full sentence?
Mr. Chairman, Senator Morrissey, what I would say in response to that is that's important for a court to be able to adjust the modification of sentence. I mean, obviously, before the changes from last time where we adopted the language of technical violations, a court could modify the sentence upon an initial violation of the terms of probation, or some of these things which are clearly new offenses may not be charged as a new offense. So I think the argument would be that this is an important measure for courts to be able to adjust to the needs of a probationer and in the interest of public safety.
Further question, Mr. Chair.
Senator Morrissey.
In other words, let's not tie the judge's hands. Let's let them have the autonomy to do what they feel is necessary.
Mr. Chairman, Senator Morrissey, what I would say is with this compromise legislation here, I think there are many who would say a judge should have that authority to not have their hands tied on these violations, but this retains the majority of the hand tying, I guess you could say, in terms of the structure of it keeps the technical violations in place, it keeps that description, keeps it in place for first offenses. It does remove the limitations for second and subsequent.
All right, thank you, Mr. Chair. Thank you, Delegate.
Okay. We've got the bill before us. Let's hear from people for and against, then we'll take up Senator Servell's idea.
For those attendees in the Zoom room who'd like to speak in support of the bill, please raise your hand electronically now.
Good morning, Mr. Chairman. Nathan Green, Commonwealth Attorney for City of Williamsburg, James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. Your Honor, Mr. Chairman, we did work extensively with this language. We've spoken with members from IDC and other places to hear their concerns and address them where we can. This is a reaction to what we were seeing boots on the ground in courtrooms with the change in probation violations. The biggest change last year was this new definition of technical violations, and that was big. But it also did some other things with regards to the term of probation. And what the first line, the line that does sound like it may stay, is extending the amount of probation on Class 1 misdemeanors from 12 months to 24 months, which is appropriate just because of the amount of effort that some probation rehabilitation services need, and the amount of time it takes to get that done. Sometimes 12 months just isn't enough. The other real needed fix is that what we see often is that an individual, through no fault of their own, cannot comply with all of the terms of their probation within the period the judge originally prescribed, 5 years on a Class 6 felony. And if they bump up or they're getting close to that end of the time, unlike the language in 303 that relates to sentencing, on a probation violation, the judge has no authority to extend the probation for the period of time it would take for them to complete the court-ordered program. We think that is needed language so that the judges aren't faced with the draconian choice of, I can either seek rehabilitation or incarceration, but not both, because I cannot put them on probation any longer. And for that reason, we needed that language. The technical violation, what we have asked is that the most significant, what we think are the most serious and not necessarily truly technical violations be removed. And that is distribution of drugs, firearms, and absconding. Absconding is not a technical violation. Absconding is the outright ignorance and disregard for the judge's order and saying, I'm not going to do this, I'm leaving, good luck finding me. And if you do find me 3-5 years later, when I come back to the court, I know that nothing can happen to me. And then I'm going to go for another 3 or 5 years. And then when I get back before the court, I only can get 14 days. Absconding is something that is not technical in nature. It is a true disregard and disrespect of the court's order. What contains are those items that would not be truly absconding, but just the individual losing track with their probation officer. If they don't make contact, if they don't advise them of a new address, that's still in technical. But if you abscond, it's not technical, it's a disregard of the court's order, and we would ask that to be removed.
Okay, thank you, Mr. Green. Are there other people in favor of this legislation?
Mr. Chairman, we have one hand raised online.
Okay, please be brief.
Steve Austin, please unmute and begin your testimony.
Good morning. My name is Steve Austin. I'm the Director of Criminal Justice Service in Prince William County, Virginia, and I'm representing the Virginia Community Criminal Justice Association. We do support the HB 758. We do feel like technical violations, the bill that was passed last year limited the judicial discretion in probation violations, and it also limited probation officers' ability to manage probationers, including technical violations. It doesn't take into account that our probation officers really work hard to employ evidence-based strategies to limit violations to start with. And we do believe that this substitute bill helps to clean up some of that legislation, and it also keeps the spirit of the bill from last year. Thank you.
Okay, thank you very much. Are there people in opposition?
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now.
Sure. Maria.
Good morning. I wouldn't say that I'm necessarily here to speak in opposition, but I did want to point out and focus on one thing exclusively. Mr. Chairman, members of the committee, Maria Jankowski, Virginia Indigent Defense Commission. I take issue with Mr. Green's articulation around absconding. First of all, I implore you, I believe that if we pull absconding out of technicals, it will in effect completely void and nullify any and all reform that happened in the past. Because I have yet to have seen a case where my client, unless they were arrested in the probation officer's office, could not be alleged to have absconded. And the case law on the definition of absconding is whereabouts unknown. I do not believe that we can pull that out neatly. I've talked to Mr. Green about trying to find a definition that can satisfy everybody. I don't believe that definition exists.
And you, with a lot of people that are homeless and indigent.
Happens.
They're often charged with absconding, the probation officer.
And if you look at the worksheets, the penalty for absconding is significantly higher than all the other technical violations. So a finding of absconding can have draconian results. So that would be my only piece on all of that, is just the absconding piece.
Thank you very much.
And the lack of a definition. Thank you.
Good morning, Mr. Chairs and members of the committee. My name is Emily Mooney, and I'm here representing Reform Alliance, which is a national nonprofit seeking to improve probation and parole policies by creating pathways to redemption, work, and well-being. As part of this mission, Reform worked with the Virginia legislature and allies such as the American Conservative Union and Faith and Freedom Coalition to pass HB 2038 last year. This bill promised to support public safety, fiscal prudence, and a strong workforce by bringing Virginia's probation policies into alignment with modern-day research and practices that are done by many states across the nation. HB 75 seeks to roll back these reforms and promote lengthy probation terms by setting a new 2-year cap for Class 1 and Class 2 misdemeanors, which means a defendant could spend 2 times or 4 times longer in probation than they could for the underlying time in jail. A length of study by Pew Charitable Trust proves that states can safely and substantively reduce supervision terms with no negative impact on public safety. I also want to address the removal of the incarceration caps for technical violations. Without these parameters, missed meetings with probation officers or other very minor failures to follow complicated rules will subject huge numbers of people to incarceration, damaging their ability to continue mending their lives, supporting their families, and pursuing life goals. This bill would drag many people back into the legal system, ensuring probation becomes a pipeline to prison rather than a launch pad for success. This will have a huge impact in already disadvantaged communities and has no public safety benefit. Thank you for your time.
Thank you very much. Are there others? Just ask you to be very brief.
Thank you, Mr. Chair. Dan Goldman on behalf of Justice Forward Virginia. I would just say that on 2 points, the drug distribution and the gun possession, these are never treated as technical violations unless they don't actually have the evidence to prove the case. They are always treated as new crimes and charged as such. This is an end run around the burden of proof, and we would ask that you oppose this.
Thank you very much. Senator Morrissey.
2 very quick questions for the patron. On lines 20 to 22, it appears that the court can fix a period of probation up to 4 times as long as the maximum statutory period. You have a Class 2 misdemeanor, maximum period of incarceration is 6 months, but the court can fix a period of probation up to 2 years. That strikes me as just way too broad, far too long for a 6-month jail sentence, being able to impose supervised probation up to 4 times that amount. Can you address that?
Mr. Chairman, Senator Morrissey, yes, I can. I think the perspective that was taken initially was that prior to last year's legislation, there was almost unlimited supervision that was available to a court that was taken down to the length of a potential sentence. This amount that's here reflects a negotiated number about what courts, pretrial folks believe, commonwealths believe are necessary for the adequate supervision in these cases, and a lessening of what was, say, prior to the most recent legislation. So I don't think this is the most important portion of the bill. However, I think that especially with respect to Class 2 misdemeanors, as you say. There aren't that many that come through. That would certainly be a subject of additional amendments, perhaps, if that were to be suggested.
Final question. And thank
Senator
you for
Morrissey.
that, and thank you for that explanation. With regard to one of the points that Ms. Jankowski brought up, it appears to me, and in my experience, that the absconding covers the following scenario. The defendant's, the probationer's cell phone is out, and they can't locate him. Lost his lease or is on the street. Anything that includes, I can't reach him right now, there seems to be a catch-all violation, absconding, when it's not the scenario where somebody left the Commonwealth of Virginia and went to Alaska. Do you see what, that's a very big concern that I have. Can you address that?
Yeah, Mr. Chairman, Senator Morrissey, yes, sir. And I did speak about this with some different folks. I think there's a couple of responses to it. Number one, I believe that, and perhaps our Commonwealth representative can speak to this in more detail, but I think that there's some safeguards in the rules themselves that sort of distinguish between someone who's truly, whose whereabouts cannot be found versus someone who temporarily is out of touch.
Delegate Adams, you know, I do probation violations fairly often, and I can tell you that situation is exactly what the probation officers call absconding all the time, every day. You know, that they've lost their cell phone, or they don't have a battery, or they don't have an address. They're on the street. They're absconded. They might be 2 blocks from the courthouse, but they've absconded. It's not like they've gone to South Dakota.
Well, Mr. Chairman, they may still have a job somewhere. They may have committed no violations. They may remain drug-free, but they're charged with absconding.
Right. Well, Senator Serval, I want to hear your idea again for your motion.
Mr. Chairman, my idea was to basically leave the extension of misdemeanor probation to 2 years for Class 1 misdemeanors in the bill and strike the rest, and then put a reenactment clause on the bill so we can continue the conversation through the end of session and conference. That was the idea.
When you're striking, you would strike the second enactment clause that repeals 19.2's 306.1.
Mr. Chairman, I would strike everything after line 86 in the bill, I believe, and then put a reenactment clause on it.
Okay.
I think also, Mr. Chair, delegates, Senator Serval said strike Class 2 misdemeanor.
I'm sorry, that's correct.
Class 2 on line 22.
I did say that.
Okay. Does everybody understand Senator Serval's motion? Is there a second to that motion?
Second.
Okay. All in favor of adopting those and put a reenactment clause on the bill? Is that right? Okay. That motion's been seconded. All in favor of those amendments, say aye. Aye. Opposed? No. Okay. That was 9 to 6. Something like that, yeah. Something like that. Okay, if the bill's reported, it's got to go to finance. Ms. Jankowski, do those amendments take care of any of your concerns?
Yes, sir.
They do? Okay. If the bill's reported, it's got to go to finance.
Second. Torture the young man. That's right. And is there a subcommittee in the finance we can send it to?
Okay, is there a substitute motion? Okay,
There won't be anything else to argue.
we'll open the roll. All in favor of reporting and re-referring to finance, vote green. Okay, you've got one more bill. That's 760.
Senator Sassler, you Senator Lucas's property. What did he say?
You've got Senator Lucas. Oh, 760.
Thank you, Mr. Chairman.
She said no. Hold on.
As I mentioned, with respect to this bill, it also deals with probation violations. This just makes one small change, and this is really broad in concern with some of the other concerns that you've heard about with the problem we have with overdoses in the Commonwealth and different drug addictions. This would remove possession and distribution of drugs from the listing of technical violations. And that's all it does for Schedule 1 and Schedule 2 substances. So the most serious offenses like cocaine, fentanyl, this would give the court more tools on an initial
Is this
probation violation.
bill a subset of 758?
No, this is brought on its own because that language was not negotiated in the broader, more comprehensive bill, but this comes at the specific request of judges and folks who have this concern with respect to drug cases.
Okay. I think we understand the bill. We haven't had this bill before, so people that are for have 2 minutes.
Whoa.
Senator Peterson's got a question.
Well, it says, I'm looking at the language, it says, if I might, Mr. Chair, including a violation based on a defendant's failure to refrain from the use, possession, or distribution. So it's not just distribution, it's use and possession.
Correct. Mr. Chairman, Senator, that's a distinction from the previous legislation we just heard. The negotiated position before was that possession would remain a technical violation in House Bill 758, but in this bill, this is applying both to the use, possession, and also distribution.
Well, further question, Mr. Chair.
Senator Peterson.
Shouldn't we just limit it to the distribution?
If that would mean the passage, I would be.
I
would take that as a friendly amendment.
Mr. Chairman.
Senator Peterson, are you
Yeah,
agree?
I'll defer to Surville, but
Surville?
yeah.
Mr. Chairman, it just seems to me that this policy can be taken up within the discussion relating to the bill we just sent out of here, and it's probably going to conference.
It goes to conference.
So therefore, I just moved to PBI the bill.
Got a motion and a second to PBI the bill. Are there other motions? A green vote is vote to PBI. Okay, thank you, Delegate.
Thank you.
And I noticed that Senator Delegate Williams, you had a bill. You didn't tell me you had another bill.
Well, I didn't actually remember that I had another
Yeah,
bill.
yeah, that's what Sir
Your
was
staff
talking
helped me
about,
with
yeah.
that.
813.
That's right, sir. This is
Senator House Bill 813 is similar to a part of Senator Reeves' bill that we reported out of this committee 14-0-1. And so I guess if we're going to do anything, we probably ought to conform it to Reeves' bill. And then Surville was the one. And if we're going to have a debate, we can have that.
Mr. Chair, I move that we conform it to the Reeves bill.
Okay. Is there a second? Second. Okay. A motion to conform to Senate Bill 328. All in favor, say aye. Aye. Okay. Do you understand what we've done to your bill?
Yes, sir.
Okay.
Mr. Chairman.
Senator Surville.
I have a question for the patron. Delegate Williams, I asked the same question of Senator Reeves when his bill came through, but do we have your commitment that if the governor makes any amendments on this, that you will not support them?
Well, I'd like to see the amendments. I don't know what
Okay,
they
so
might
that's a
be.
no. Okay.
I don't know what they might be. Maybe they're good.
Mr. Chairman,
Senator Surville.
I would ask, Delegate, would you like the bill to pass today?
Yes. Yeah.
Hey.
But I'll tell you.
Hey. Leave him alone.
But I'll tell you that I have not heard of any comments that we're going to try to pull something like that. That'd be news to me.
I think Senator Reeves said yes, didn't he?
Right. Yeah, just say yes.
Well, he got a bill passed. He said yes.
Oh, what was the question again? I'm
The
sorry.
question is, will you oppose any amendments to the bill that come from the governor's office?
Sure.
There you go. I
Sure.
move to report.
I'm one man, so sure. There's 140 of us.
I move to report.
Okay, got a motion and a second to report the bill. All in favor, vote.
I've got some
green.
more bills coming through.
Pardon me, this needs to go to finance, Mr. Chair.
It does need to go to finance? Well, it's not on my list.
Oh,
but
sorry,
that's-
pardon me, no, it does not.
Okay.
Sincere apologies.
Motion to report the bill. All in favor, vote green. Okay, congratulations.
Thank you,
Delegate.
sir.
1 out of 2.
Mr.
Okay.
Chairman,
Senator Morrissey.
I'm always happy when students from either local schools or from around the Commonwealth come into Judiciary to see how some of our laws are made. And we had a group of students that came in from the back, and maybe if you could, from, I think, Prince William County and others, just wanted to recognize them. They're seeing how the laws, particularly those involving criminal justice, are made.
Well, welcome, students. Welcome. Okay, Delegate Sewell, we've saved the best for last, right? Yeah, well, we've got the two bills we got worked on since the last meeting, yes.
Okay. Well, it's great to be back before you all. Thank you, Mr. Chairman. Mr. Chair, members of the subcommittee, of the committee, House
This is
Bill
434.
434 expands the definition of intimate parts and protections for victims of criminal sexual assault. The bill was inspired by my constituent. At the young age of 12 years old, she had to fight off the sexual assault of a 37-year-old man. Despite the proper reporting to law enforcement, my constituent's perpetrator walks free because she referred to her chest and not her breast on the witness stand. I wish I could tell you that this is the only case of this nature, but I cannot. Similar rulings have been made in the other judiciary circuits of Virginia, all due to the simple word choice of a child. Today, we have the opportunity to prevent this from happening to others.
Okay, do we have an amendment or?
Mr. Chairman.
Senator Servo.
Charles, did you prepare a sub? Yeah, Mr. Chairman, Charles prepared a sub that basically restores the bill to what was introduced before it got some amendments in the House. I would move the substitute. Basically, thank you.
What the substitute does is it basically just says chest area of a person under 13 years of age. 15? Okay. All in favor of the substitute, say aye.
Aye.
Okay, the bill's before the committee.
Mr. Chairman, this one does need to go to finance.
It does need to go to finance. Okay. So motion to report and re-refer to finance. Has there been a second? Okay. All in favor, vote green. Okay, we've got two bills left. Delegate, congratulations.
Thank you.
We've got two bills left. Senator Delegate Clark has a bill. Okay, I've got one more bill after this.
Good morning, Mr. Chair and members of the committee.
And then we've got a substitute on this bill as well, don't we?
Yes.
Okay. Do I have a motion on the substitute? Okay.
Second.
All in favor of adopting the substitute, say aye. Aye. Okay. This is the bill that has to do with limit on criminal or medical bills. And Senator Peterson, Senator Servo, I think we're working on this. Okay. Senator Servo.
Can we try and explain it?
Yes.
Mr. Chairman, I'm waiting to get it here, but this was actually a lot more complicated than I think I anticipated. First of all, it makes it clear, if you look at lines 27 through 29, it sets a 3-year statute of limitations for any claims relating to debts arising out of healthcare services, which is healthcare services provided by a licensed healthcare provider. And actually took a few rounds to get that where we wanted it. The more complicated piece is on the accrual provision. And I'm not sure we're exactly 100% there yet. I did about an hour Zoom yesterday with about 8 people trying to get the accrual provision in place. But the problem with accrual is that
that's in subparagraph 10 on line 79.
Yeah, set lines 79 through 84. And by the way, Senator Peterson wanted the enactment clause on there, which is in there. But basically, the way the accrual works under this is the statute of limitations begins to run at the later of either 30 days after the issuance of the initial invoice to the person, or if the patient is in a payment plan 30 days after the default date in the payment plan. All of this is subject to tolling if there is any lien that has been perfected in writing pursuant to 801-66.5, and that has to do mainly with personal injury cases. Because sometimes plaintiff's counsel and patient and healthcare provider will enter into a lien agreement on the debt while the PI case is pending. And the thought was that the statute shouldn't run while that lien is in effect, but only a lien that's in writing. There can actually be liens that are not in writing. We limit it to liens that are in writing. And there's about 6 different liens in that article. And there's a bunch of smart people looking at this, trying to make sure we didn't create any unintended consequences as we work through it. And we all sort of committed to sort of run this out, run the traps on this language, and then, there's a possibility this could have to go to conference to clean it up a bit, but but I think we've got it about as tight as we can get it for now today.
Okay, does anybody have any questions of Senator Servell or the delegate? Move to report. Does this have to go to finance?
It does not, Mr. Chair.
Okay, a motion to report, and it may have to go to conference, but that's okay. Is there a second on the motion? Second. Motion and a second to report, or the substitute motions. Open the roll, a green vote is a vote to report. Okay, thank you, sir.
Thank you.
Okay, there's one other bill, I didn't,
Mr. Chairman, we have one bill left, House Bill 623.
623. And I got a text from Delegate Hudson, she's stuck in a committee.
That's okay. It's similar to Senate Bill 514, and actually the technical amendment has to be made on the Senate bill, so Delegate Hudson's bill is, the concept is already passed out of this committee. It was a part of Delegate.
Three
Senator
bills
Pike's
came to
bill.
this committee, they're parts of Senator McPike's bill. Okay. If there's a motion and a second to report, all in favor vote green. Okay, Delegate Peak said that he had something to enlighten us about.
Not to enlighten, Mr. Chairman, but I have a question, a serious question. And I guess we all got this handout about this Carolina squat vehicle that caused the deaths. And so I understand it was considered under a part of Ronnie Campbell's bill. Is that correct, Mr. Chairman?
That's correct.
Mr. Chairman, and I would ask then if this committee has any appetite, or if I could consult with counsel. I mean, this vehicle is not safe to be driving down the roads of the Commonwealth of Virginia. We should do something about this. We have the ability to address this situation. It just happened, and we should. Nobody should be driving down our roads in something that looks like this. What would we have to do?
Senator Peak, if you want to have a bill drafted and have it introduced, I will vote for you for unanimous consent.
Could we do a unanimous consent, and could we bring it to the chair at your desk, or are we meeting
If you
on
could get it
Wednesday?
introduced, we take it up, yes.
On Wednesday?
We take it
And
up.
then let me ask, is there an appetite for this committee for me to make them go through this work and to do this work to pass something that would prohibit this vehicle? I see Senator Morrissey. Anyone else?
I would say it's reckless drive.
Well, it's not reckless because it's the vehicle. I mean, unless he's speeding or something, it's not reckless.
Mr. Chairman.
Senator Morrissey.
I'm not sure everybody saw this. You can't see over the wheel when you come up a hill. It's a picture's worth 1,000 words. It's an unsafe vehicle to drive. This resulted in the death of an individual. So I think the senator would have to ask for unanimous consent, bring it before the next Judiciary Committee, pass it out, and
Would you be interested, and then the appetite?
Mr. Chair,
Yeah.
question.
Senator McClellan.
Would such a vehicle, how does such a vehicle pass the state inspection?
And that's why I need to consult with counsel
Miss-
as to find out. But
They
if-
unjack it and then jack
Now,
it back up after
There
the
may be
inspection.
one additional bill that comes here from Education and Health. If there is, we'll have another committee meeting.
All right, I'm
But
going to consult.
Otherwise,
Thank you.
we're done.
Thank you,
Okay,
Chair.
thank you.
Yeah. They take it down and then they jack it back.
I'm not sure they have to.